Article 18, Article 18, paragraph D of the Constitution of the United Republic of Tanzania states clearly that every person has the right to be informed at all times of various important events of the life and activities of the peoples and also issues of importance to the society. Your Lordship, it is clearly shown that in Article 18, subparagraph D of the Constitution of the United Republic provide a right of every citizen to a full participation. But when you come back to what has been encroached in Article 10 of the IG agreement, it set out the issues of confidentiality, that there is no in any other point where the third parties will have to be included or be informed upon any kind of information relating to the contract. So it shows clear that it contravenes Article 18, subparagraph D of the Constitution of the United Republic of Tanzania, that's amended time to time. Because the citizen of the United Republic of Tanzania will lack the essence of participating fully concerning the matters relating to their affairs. Your Lordship,
to stipulate that each conflict to be aroused in the argument shall be resolved in South Africa. Our Lordship, this article 20 contravene with our Constitution, that is Article 27 of United Republic of Tanzania, Constitution of the United Republic of Tanzania, which stipulated well in fundamental right that every citizen of the United Republic of Tanzania has duty in protection of the natural resources. As we know, what is the amount of natural resources? My Lord, I would like to advocate on the prevention of interference in the implementation of the argument that Article 6 of 2 of DPL has prevented our citizens or our public from interfere any implementation that contravene with Article 9 and submit.
Your Lordship, the provision of Article 2 of the Intergovernmental Agreement is contravening our Constitution in Article 9J, the Constitution of the United Republic as amended 10 then. If you will allow me to read Article 2 of the Intergovernmental Agreement between the United Republic of Tanzania and Emirates of Dubai, provided that the objective of this agreement is to set a legal binding framework of area of cooperation for the development, improvement, management, and operation of sea and lake porting, especially economic zone, logistic parks, trade corridors, and other relative strategic port infrastructure in Tanzania. This area is cooperation also including capacity building, transfer of knowledge, skills, technology, strategy, training institution, and marketing support. This article has asserted that it contravenes Article 9J of Constitution, which pursues to Ujamaa and self-reliance. This article cannot send itself without consider or prefer Article 5 sub 2 of IGA, which is needed to inform Emirates of Dubai if we have another company does not have a power to enter into an agreement with another country, because the matter of national international relation with another state concerned to the Union of Emirates of Dubai. Thank you. Yes, please.
My lords and my lord in justice, the aforementioned grounds on the invalidity of the intergovernmental agreement between Dubai and Tanzania are very enough to declare this contract null and void, but allow me to add two more grounds. My lords and my lord in justice, this agreement, intergovernmental agreement between Tanzania and the DP World, famous known as DP World, is contravening with the right of the citizens of Tanzania to participate fully in decision making in matters that they affect themselves directly or indirectly, which have been provided by Article 21 of the Constitution of the Republic of Tanzania, as amended from time to time. If you allow me, Your Honor, my Lord, if you allow me, my Lord, please allow me to read that article. Article 21, Article 2 of the Constitution would states as follows. Every citizen has a right and the freedom to participate fully in the process leading to the decision on matters affecting him, his well-being, or the nation. Now, my Lord, I'm saying this, that this contract violates this article specifically simply because before signing and ratifying of this contract, the government and parliament failed to provide duly notice to the public members and reasonable time for them to make opinion on what is right or wrong and on what is going to affect them, which is the control and management of both. Why so? My Lord, the government provided a notice, actually, but I'm saying that the notice was not duly. By duly, I mean the notice was not correct and in accordance with the law. Why am I saying so? My Lord and my Lord of Justice, the notice provided by government was only for 24 hours, and the meeting for collecting those opinions was conducted on the 6th June of 2023 at Dodoma. My Lord, it is known that in Tanzania there are more than 20 regions, and it needs more than 24 hours for someone to come from a region far from Dodoma and to be in Dodoma for him to provide his opinion concerning the matter of intergovernmental agreement, which in one sense affecting him or her directly and his nation directly. So it becomes important for a person from there to travel within 24 hours to be in Dodoma and provide that opinion. So the notice was provided within a time which was not reasonable. So providing a notice in such a short period of time is like you are speaking to citizens for providing opinions on the matters which are going to affect them directly. So that actually the time provided and the notice was issued, but the time was not reasonable. So this is a very enough reason to declare this agreement null and void, specifically this procedure whereby the government and parliament did not provide a notice. My Lord and my Lord in Justice, I'd like to provide how this issuance of notice, which was not in accordance with the law, affected this contracting. As I said, firstly, it contravened with the Article 21, Sub 2 of the Constitution of the Republic of Tanzania, as amended from time to time. But also, as you can see, the result of this meeting, which was conducted by the government to collect opinions from these citizens, it only included opinions from 72 people in the whole Tanzania. My lords and my lord in the justice, Tanzania has more than 45 million people. That is according to the last census. Now, my lord, out of these millions of people in Tanzania, only 72 of them have provided opinion on the matter which is going to affect your system. You may see how ineffective and inefficient this provision of notice, which was issued by Parliament and government, was. Reaching only 72 out of millions of people, you can say that decision was a public decision. So it's obvious you have contravened their right to participate fully in the matter of decision making. My lords and my lord in justice, this situation was provided clearly in the case of the Mayor and Corporation of Port Laws and the Honorable Attorney General of Mauritius. Please take consideration of this case when deciding. Now, that was the first reason which concerning the participation of public in the making of decisions in the matter which affects them, which Parliament and government absolutely ignored that right and made we citizens to suffer from their decision, which as citizens couldn't make and not given the chance to make those decisions. My lords and my lord of justice, that was the first ground from me. The second ground was concerning the sovereignty. My lord, Tanzania is a sovereign country, and this is provided under Article 1 of the Constitution of the United Republic of Tanzania, as amended from time to time. If you allow me, please, my lord, I'd like to read it